Believe it or not, the anti-gunners are arguing that AR-15s should be banned, and they're trying to justify their quote-unquote assault weapon bans, which is, are just bans on ordinary semi-automatic rifles, because the rifles are too lethal. That's right, lethality is the reason why they need to be banned, because they're too dangerous. Well, let's debunk this argument real quick when we get back. Hey folks, I'm Mark Smith, host of the 4Box of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. A lot of lessons from the Ukrainian mistakes there and how the Ukrainians dealt with the Russian invasion using small arms, and a lot of lessons there for Americans why we should never give up our small arms and our right to bear arms here in the United States. All right, folks. So there's an argument that's making the rounds now. I'm flagging it now. I'm going to talk about it now, give you the arguments you need. Very important. We're seeing this in the Illinois cases involving Barnett versus Rowell, and also the Bevis case, the Naperville case involving the various arguments out there involving the assault weapon ban. And we're also seeing this in other cases all across the country dealing with the anti-gun attempts to ban semi-automatic rifles such as the AR-15 and AK-47 semi-automatic versions. So specifically, the argument goes along this lines. I'm going to paraphrase it. It gets raised in the same idea, but it essentially says this, that the government is arguing that, or the government is trying to demonstrate that assault weapons, which are semi-automatic rifles, are uniquely lethal instruments that were developed for the military, for offensive uses in the military, and not for civilian self-defense. And it's wholly inappropriate for civilian self-defense because they are, among other things, too dangerous or too lethal for American civilians. Now, set aside the fact that these same quote-unquote lethal weapons are used by basically every single law enforcement agency in the United States, including when I walk through Times Square in New York City, I see the police officers in Times Square holding AR-15 style firearms. They probably have select fire there, but they certainly are ARs at a minimum, and one wonders if the police in America, including in Times Square, need AR-15 semi-automatic style firearms and rifles. Well, we walk the same streets as the NYPD, so it seems to me we should be getting the exact same weapons that they get, and I say that's the case all across America. So just with that general observation, let me go down and break this argument down more specifically. First of all, the Supreme Court has repeatedly said that when it comes to defining our rights, our individual fundamental rights, such as the right to keep and bear arms, we do not define or lose our rights by virtue of how an activity can be abused or misused, right? The mere fact that an organization can defame someone or can commit fraud or can commit some form of a theft or do something else improper, like, again, commit libel or slander, does not mean that you and I lose any of our right to free speech or First Amendment rights. So, too, the fact that someone might misuse a firearm is not a basis for you and I as law-abiding Americans to lose our Second Amendment rights or to allow that to be curtailed, including via prior restraint, as I see it. And the Supreme Court has repeatedly reiterated this notion. To begin with, if you look at the Heller case, they specifically laser focus on the lawful purposes of firearms. In the Heller case, they talked about handguns. Specifically, they basically adopted the in common use test based upon the Miller case, which was based upon the history of the Second Amendment, meaning the history of, Americans could have commonly owned firearms for the purposes of, among other things, showing up for militia duty, and that's why weapons that are in common use by Americans for lawful purposes are protected. But did you hear what I just said? The focus on the standard as to whether or not an arm is protected is how do Americans lawfully use these weapons. It has nothing to do with the fact they can be misused, because anything can be misused. In fact, if you look specifically at the Heller case, if you look at the majority opinion, they say very little about any kind of quote-unquote gun violence or the misuse of firearms. In contrast, if you look at the dissents in Heller, they talk all about how criminals misuse firearms, but the majority opinion didn't really care about that because their view was, well, anyone can misuse anything, and the fact that people commit crimes is not a basis for taking away Mark or your right to keep and bear arms. That's not how we measure or evaluate constitutional rights in this country. Beyond that, do not forget this critical timing component, this temporal component juxtaposition. Never forget that the Heller decision was decided in 2008, but what happened in the year of our Lord 2007, right before the Heller case? Well, unfortunately, there was the Virginia Tech shooting where a single man using semi-automatic pistols, i.e. handguns, shot over 30 people and killed many people in that terrible tragedy. But the bottom line is, notwithstanding that, and notwithstanding the fact that the U.S. Supreme Court was certainly aware of the Virginia Tech shootings, in 2008 they decided Heller, which again upheld the right to bear arms, because again, the fact that some crackpot at the University of at Virginia Tech can misuse firearms is not a basis for us to lose our rights. So that's just sort of clear that makes common sense, and also, of course, is what the Supreme Court has actually said. But beyond that, let's talk about who decides, and this is important, who decides when a firearm is suitable for self-defense. Who gets to make that decision? Is it we the people, meaning you and I, the people that are going to defend our own lives, or does the government get to dictate what we get to use for self-defense? Well, we know it's we the people get to decide that, because if you look at the Heller case, again, which remains perfectly good law, it was reaffirmed by Bruin 10 Ways to Sunday. And Heller said specifically that for whatever the reason is, Americans overwhelmingly choose handguns for the purposes of self-defense. So they're in common use and they're protected and they cannot be banned. And again, it doesn't matter that there were alternatives, because if you remember, the government in Heller specifically argued that they were allowed to ban handguns. I repeat, the government in D.C. in the Heller case said, we, the District of Columbia, can ban handguns. Why? Because we let D.C. residents have access to long guns, rifles, and shotguns. But the Supreme Court says, no, that's irrelevant. That you, D.C., don't get to choose the arms that Americans pick for themselves to protect themselves. They get to make those decisions for themselves, because we are governed by we the people. And as a consequence, the question is, who gets to determine when is a weapon suitable? Because specifically, if you look at the arguments they're making, like I took a look at some of the cases, some of the briefing in the Illinois assault weapon ban case, and specifically what you see them arguing is they make comments like this. Not only do assault weapons derived from military-grade weaponry, their features render them uniquely effective as weapons of war, but not commonly used or suitable for civilian self-defense. So here you have, Illinois and their friends, the city of Naperville and so on, and the city of Chicago, I presume, and all of them, are going on arguing that these AR-15s, these semi-automatic rifles, are not suitable for civilian self-defense. But that's obviously not true, because Americans pick them overwhelmingly for self-defense. That's why people own these guns, or a reason why they own these guns. And again, who gets to determine what type of car we drive? Do we get to decide that, or does the government? Now, I know that the anti-gunners and a lot of people on the left want to be able to decide all these things for us, including what kinds of guns we get. But trust me, if you let the anti-gunners determine what kind of guns we get, we'll be back to single-shot, dueling pistols with black powder in about one day. But again, thank God we have the Second Amendment, and a lot of Americans will not support such nonsense. But anyway, again, the question of suitability is determined by we the people, and not they, the government. Never forget that. The next point I want to make about this argument that semi-automatic firearms, semi-automatic rifles, and AR-15s can be banned because they are not suitable for self-defense, or they're too dangerous and thus they're too lethal and can be banned because of their lethality. Here's kind of a weird argument that they make. If you look at the arguments they're making in Chicago, in Cook County, Naperville, and so on, they're basically saying that, hey, here's the story. All these extra features, sometimes they refer to bayonet lugs in the context of the 1994 assault weapon ban. Sometimes they talk about flash suppressors. Sometimes talk about protruding pistol grips, whatever it is, collapsible or folding stocks. Whatever it is, these other features that turn an ordinary rifle into an assault weapon, according to sort of anti-gunners and certain laws across the country. What's interesting, of course, is they argue that these features that get added onto AR-15 semi-automatic rifles make these weapons more effective for criminals. Did you hear what I just said? The argument by the anti-gun side is by adding these features that make these firearms more effective, more accurate, thus more lethal in the parlance of the anti-gunners, it makes it easier for criminals to kill more people faster. Well, that is conceptually true. The more effective firearms are, the more they can be used efficiently, whether it be for good purposes or bad purposes. No different than a fast car. The faster a car goes, well, same concept, right? Can be used for good or for bad purposes. But here's the key point. Keep in mind that, and this is very important, any benefit to firearms efficiency, to firearms accuracy, to firearms lethality, right? Any improvement in firearms technology that a criminal can benefit from in engaging in criminal conduct, guess what? Those same benefits to the criminal are the same. In fact, they're actually more so to the law-abiding American. What do I mean by that? You see, when a criminal takes a firearm or any weapon and goes into a laundromat or a restaurant or a jewelry store or what have you to commit a crime, that criminal or those criminals, they often attack in groups now, they're coming prepared. They're acting. They are ready to go. They already know what they're going to do, and they're going to do whatever it takes to accomplish the mission, whether it be to kill as many people as possible, or to steal the jewels, or to steal the money, whatever. In contrast, ordinary Americans have to react. That's right, we have to react to the criminals. The criminals have a distinct advantage because they get to attack and act. And action always beats reaction because we're just sitting there having lunch, or we're just sitting at a counter, or we're just looking at the sky, and next thing you know, we're under attack. We're in a state of war, and therefore, any single thing that we can do to improve the firearms we have on our body, because the odds are the only thing we're going to be able to use is what's in our pocket, or what's in our holster, or what's on our body. That's it. We're not going to be able to go home, go to the car, none of that's available to us because we're reacting to the attack by the criminal, by the thug. So any benefit to firearms technology that could conceivably help the criminal do a better job of committing crimes, if you will, right? It's actually more important that we have that, because if it benefits the criminal, it benefits the law-abiding citizen by making that firearm more proficient, more effective to protect our lives from thugs. And we need that technology far more than criminals do, because the criminals, A, can violate every law under the sun. We'll get to the Cesare Beccaria quote in 1 second. Then they will violate it. If they're willing to commit murder, they certainly don't care about any gun control law or using a weapon that has the improper feature. It's irrelevant to them. But again, we need at least as much firepower, if not more so, right then and right there, because again, we're already at a distinct disadvantage to the criminal because we're reacting to the attack while they get to act and prepare ahead of time. We don't have months and months to prepare for this attack. We literally are going to have to react in a matter of seconds, when the criminals have months to prepare in theory. And some of these, of course, are long-standing planned. If you look at what happened apparently in Nashville with the shooter in the Nashville school, which we still haven't seen the manifesto, but from all reports it appears that came about after a considerable amount of planning by the psychopath in Nashville. On a related note, I want to remind you all about the famous Italian Enlightenment philosopher, criminologist by the name of Cesare Beccaria. I've talked a lot about him, and the reason why he is so important is because he wrote a critical book, which I'll put a link to down below. In fact, I'll put a link to my Pepperdine Law Review article where I discuss the importance of Cesare Beccaria to giving rise to various aspects of the Bill of Rights, including the Second Amendment. But Beccaria is extremely important for you Second Amendment supporters out there, because it was Beccaria's books, it was his writings, it was his theories that our founding fathers read, were familiar with, and used in part to craft the Second Amendment to ensure we have a right to keep and bear arms today, which codified the pre-existing right. That's what the Second Amendment does. It doesn't create any rights, it codifies pre-existing rights. But this is very important because both Thomas Jefferson and John Adams both wrote down in detail the quote I'm about to give you from Cesare Beccaria, who was a staunch anti-gun control person. He completely supported the right to keep and bear arms. And here is what he says. It's very powerful language. He starts off by saying, this is Cesare Beccaria, before the Constitution was written, this was used by our founding fathers to draft, among other things, the Second Amendment. Beccaria writes, quote, "False is the idea of utility that sacrifices 1,000 real advantages for one imaginary or trifling inconvenience. That would take fire from men because it burns, and water because one may drown in it." Do you see what Beccaria just said there? If all you're trying to do is to ban things that could conceivably hurt you, that means you would have to ban fire and water, despite all the great advantages from that. And again, that's the same idea that the anti-gunners, don't ever forget though that the anti-gunners don't want to ban guns. They just want to ban you and me from having firearms. They and their friends in the government will always have guns, as will, I'm sure, their private bodyguards. But you and I they want to deny us the ability to have guns. They don't want to get rid of guns. They just want to get rid of you having guns. They, I can assure you, will continue to have the guns. Now, the next thing Beccaria says here, and again, I'll put a link to this down below. It's a great quote. You can use it on Twitter. Just make sure you quote Beccaria and not Jefferson Adams, because Jefferson Adams wrote this down, but the quote's originally from Cesare Beccaria, although both of Adams and Jefferson would agree with all of this. He goes on to say that the laws that forbid the carrying of arms are laws of such a nature, meaning not a good idea. They disarm those only who are neither inclined nor determined to commit crimes. You see what he just said there? They're only about designing to disarm law-abiding Americans, law-abiding citizens, and not actual criminals. He goes on to say, and this is very powerful language in the 18th century, Cesare Beccaria, the criminologist, can it be supposed that those who have the courage to violate the most sacred laws of humanity, the most important of the code, will respect the less important and arbitrary laws which can be violated with ease and impunity, and which, if strictly obeyed, would put an end to personal liberty, so dear to men, so dear to the enlightened legislature, and subject innocent persons to all the vexations that the guilty alone ought to suffer. You see what he's saying there? What he's saying, of course, is that people who are willing to commit murder, robbery, rape, and these terrible malum in se crimes will have no compunction or no concern whatsoever about going out there and violating gun control laws, which are really arbitrary and meaningless at the end of the day, only designed to disarm the law-abiding. And that's what Beccaria says. And again, he says this in the 18th century, long before the creation of the NRA, long before anybody could say the pro-gun movement engaged in sloganeering and propaganda. This is the founding, one of the most important philosophers that the founding fathers read and trusted and used in crafting our Constitution, including our right to keep and bear arms in the Second Amendment. And the last but not least, Beccaria goes on to say all of this very powerful language. He goes on to say about gun control law specifically, quote, such laws make things worse for the assaulted and better for the assailants. They serve rather to encourage than to prevent homicides. For an unarmed man may be attacked with greater confidence than an armed man. Wow. 18th century, Cesare Beccaria, writing this in his book, which I talk about in the Pepperdine Law Review. This was used, specifically written down in their books. Both Thomas Jefferson and John Adams were very familiar with Beccaria, as were all the founders. And again, very important. And of course, what all this means is banning guns or disarming Americans or disarming citizens does nothing but help the criminal. So too, by denying Americans the ability to have the most proficient and effective firearms, including those features that allow firearms to be shot more accurately and efficiently with greater accuracy and whatnot. Obviously, these benefit the law-abiding more so than the criminals, because again, the criminals don't care about any of these laws. We're the ones that will be hamstrung. We're the ones that will be encumbered. And we, as Beccaria references, we will be the one punished because we will be the ones that follow the law. And of course, the criminal class has no interest in following any of the laws. And if they're willing to commit murder, they're certainly willing to break a gun control law. That is pretty obvious. So again, keep in mind the anti-gunners in a lot of their briefs recently in terms of arguing why AR-15s can be banned, semi-automatic rifles can be banned. They're laser focused on arguing that these are too lethal for civilian use. But again, remember, we don't measure how they can be misused. We focus on how they can be used or are used by Americans for lawful purposes. The question of suitability is up to us, we the people, and not they, the government. And of course, never forget the critical lessons of Cesare Beccaria that says that gun control laws only benefit the criminals, the homicidal maniacs. They do not benefit the law-abiding because, of course, criminals don't follow any laws. And if you're not willing to follow the laws against murder, they certainly won't follow the laws involving gun control. Okay, folks, I hope you learned a little bit something here today. Got a lot more to cover this week. And if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.